Namaskar, sir.
Namaskar. Introduce yourself, please.
So, my name is Ankita Panigrahi. I have been born and brought up in Cuttack. So, telling about my qualification, I graduated from Deela College, Cuttack. Before that, sir, I have done my plus two from Shailawala Women's College. So, my schooling has been in Cuttack, and so currently I'm for judiciary.
Okay. What were your subjects in optional subjects in the OJS examination?
So, law of crimes, so law of property and personal law, sir.
What is affray?
So, afraid. So, when two or more person is fighting in public, they're said to commit an affray.
What is writing?
So, when force or violence is used by an unlawful assembly, then that converts into a riot.
What is dacoity?
So, when robbery is committed by five or more person, that robbery becomes dacoity.
What is mischief?
So, mischief is when some person with knowledge or intention that it is likely to cause damage to public or any person destructs any property, he is said to have committed mischief.
What is the difference between fraudulently and dishonestly?
So, in fraudulently, there is a intention to deceive, sir, which is not present in there in dishonestly. So, in dishonestly, there must be wrongful gain caused to some person and wrongful loss caused to some person, sir.
What is the difference between culpable homicide amounting to murder and culpable homicide not amounting to?
Yes, sir. So the culpable homicide amounting to murder has been given in section 300 of IPC, while as culpable homicide not amounting to murder has been given in explanations given to the section 300. So, like in conditions such as when the offense is committed after taking consent of 18 years or above, and when an offense is created in excess of private defense, those cases are culpable homicide not amounting to murder. But when there is an intention to cause death, or knowledge that likely to cause bodily injury as is likely to cause death of the person to whom the harm is inflicted, or the act is such of a nature that imminently dangerous or in sufficient cause sufficiently grave enough to cause the death of the person, so in that circumstances it would amount to murder.
What is cheating?
So in cheating, there is intention to deceive, while by the person cheating must have induced some person to deliver him some property, or uh, 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 or causes that person to do something or omit something which that person would not do or omit if he has not been induced thereby.
What is doctrine of double jeopardy?
So, doctrine of double jeopardy stems from Article 20 of Constitution, whereby a person already acquitted or convicted cannot be again tried for the same offense.
Is there any exception in the CRPC for trial of a person who has been acquitted for the second time on the same facts?
Yes, sir. That has been mentioned in Section 300 of CRPC, where the consequences are later on discovered, or where there is consent of state government taken before the trial, that can be done, sir.
When a police officer can arrest a person without warrant, and what procedure are to be followed?
So, police officer can arrest without warrant.
No.
Yes, sir.
Okay.
So, yes, so under Section 41 of CRPC, when a person commits any cognizable offense in presence of the police officer, he may arrest him without warrant. And if a information is received, a reasonable suspicion exists, or a credible information has been received that such person has committed a cognizable offense, then police officer can arrest a person. And if the that offense is 7 years less than punishable with less than 7 years, there is a checklist provided under section 41 subsection 1 clause b subclause 2, which has to be kept in mind in that person.
What is the difference between criminal misappropriation, criminal breach of trust?
So, in criminal breach of trust, there is an entrustment to the person who committing breach of trust, or there is a dominion over the property of that person. But that is not so in the case of criminal misappropriation, sir. And the so criminal breach of trust is provided in 405, whereas it is criminal misappropriation is provided in 403 of IPC, sir.
What is contributor negligence?
So when the plaintiff is itself negligent in the act caused by the defendants, it amounts to contributory negligence.
What is Ryland versus Fletcher Group?
So it talks about strict liability, sir.
What is absolute liability rule?
So absolute liability, where so it was developed in MC Mehta versus Union of India, whereas a person is absolutely liable for the harm caused or the injury caused to public at large, without any
What is the
exception.
what is the difference between absolute liability and strict liability?
So the basic difference is that strict liability accepts some exceptions such as act of God, plaintiff the wrongdoer, whereas in absolute liability, so there is no such exceptions granted.
What is mortgage?
So mortgage is the transfer of some specific interest in immovable property to with the intention to create a security over a money advanced.
Okay. What is exchange?
So exchange.
Exchange.
So when two persons mutually interchange the ownership of one another, the transaction is said to be exchange.
Who is a hostile witness?
So a hostile witness is a witness who goes against the party calling him and gives witness against the party calling him.
How a document is to be proved?
So document is to be proved.
Content. How the contents of a document is to be proved?
So by itself producing the document in the court.
How the handwriting is to be proved?
So by so by comparing the handwriting of that person with that handwriting sample, or so by calling expert, or so by calling some person who is acquainted by the handwriting.
If character of a person is relevant,
So it depends if it is civil, is it a civil nature or criminal nature.
what is the difference between custom and usage?
So custom is a rule that is established from time immemorial, whereas usage is not so long as custom and just developed by the usage, as it the term suggests, by using.
What are the requirements for filing a petition for divorce by mutual consent?
So if the parties have checked that there has been no relationship between them. Sorry, sir, I'm not able to say this.
When a woman is justified to live separately and to claim maintenance from the husband,
Yes, sir. Yes, sir. So, if a husband is living in adultery or keeps a concubine, or he has converted to another religion, or so becomes a hermit in that situation, so or commits desertion.
there is a married couple, there is a couple, Hindu couple. The wife is neglecting to prepare food, and also neglecting some neglect is there to take care of the in-laws. If he, on this ground the husband can claim a divorce,
So, if it is affecting his mental condition or if it is amounting to emotional torture, so,
I gave you the right. Only two examples.
so
This
in that
happened.
so in that way, I feel he cannot file divorce only for those cases.
Supposing the husband makes aspersion that you are a barren lady on two occasions, whether the wife can claim for divorce.
So, what did the husband claim?
You are a barren lady. You are not bearing child. On two occasions, husband had blamed the wife. If on that ground the wife can take divorce,
Mm, so I feel no, sir.
what is a declaratory suit?
So declarative suit.
Declaratory suit.
So
Declaratory suit.
where a suit is filed for any status or legal right, then that suit is called declaratory suit.
When it is to file.
So when some person is denying that status or legal right, or interested in denying such right or legal status, then that suit may be filed, sir.
What is mandatory injunction?
So mandatory injunction is given under Specific Relief Act, where there is to prevent the breach of an obligation, whereby compelling a person to do certain act.
In which year you completed your LLB?
So in 21.
21. Whether you have any legal background, any of your parents is, is a lawyer or not?
So my father is an advocate.
Why you are why you are not choosing the advocate profession?
So I joined law with that intention only. But sir, after knowing what law is, I found out that though I admit advocate and justice both, a judge, both are indispensable for justice delivery system, but the role of a judge for me is utmost, sir. So
Don't you
from
don't you think that if meritorious students having depth in law, they come and join the service, and thereby the bar is becoming empty of talented persons.
sir, I feel sir, both the fields require meritorious students. So why not?
Since you are a native of Cuttack, you are residing in Cuttack, you have more scope in this advocate field. You may become High Court judge. Why you are coming here to join as a judicial officer and to go from Koraput to this Malkanagiri and to lose your that jail, etc. After some days you will forget your law. Why this up?
No, sir, that's not the case. So, adversities happen in any job you are in. But, sir, my prior determination is to be a judge. So, from the childhood only, so I am determined to be a judge.
Yes, I will give you feedback after the second round of interview is done.
Yes,
Thank
thank
you.
you. Sir. Thank you, sir. Sir, namaskar.
Namaskar. Good afternoon, Ankita.
Good afternoon.
How are you?
So, I'm fine. So, how are you?
I'm good as well, thank you. Uh, Tell me whether any bail that is granted by a police officer be cancelled by a magistrate.
So, by magistrate?
Yes.
So, if there is a breach of any condition, uh, sir, as police officer can grant bail under 436 in case of bailable offense only. So if there is any breach of the bail, so magistrate can cancel it under section 2 of 436.
Do you understand why protest petition?
So I can I take a moment, sir?
Yes, sure.
So as per my limited knowledge is concerned, so when a investigation is done by a police officer is completed, the person who is uh, adverse who thinks that investigation is not conducted in a proper way, so he can file a protest for petition.
Okay. And what is a production warrant?
So warrant, when warrant is produced or issued for production of anything, so I'm guessing it, I'm not sure about it.
Okay. Okay. Tell me whether the further investigation under section 156 clause 3 is at pre-cognizant stage or at post-cognizant stage. It can be done at post-cognizant stage or pre-cognizant stage only.
uh, so investigation under 156 subsection 3,
Yes.
so that is done while a case is presented before the magistrate to take cognizance.
So that means after cognizance it cannot be done.
So I'm not sure about it.
What is the meaning of may presume, shall presume, and conclusive proof?
The may presume, shall presume, and conclusive proof are given under Section 4 of Indian Evidence Act, whereby when the act may presume something, the court may presume it to be proved unless until it is proved, or may call for the proof of it. And whenever it is directed that the court shall presume unless until it is not proved. So, but a fact is said to be conclusive proof of another fact when the court conclusively takes that matter as proved.
Okay. What is a latent defect?
So, where the defect is not in the face of the document, but while connecting it to the meaning, there is a defect. So, that is called as a latent defect.
Okay. I tell my advocate that I have committed a crime. Okay. And then after a year, I disengage that advocate. That means I have engaged another advocate. And that advocate now goes and discloses it in front of someone that I have committed the crime. Whether that communication is protected or not.
So, it is not permitted for that advocate to communicate it. So,
Okay. Can you tell me who is a child in conflict with law?
so any juvenile who has been convicted with an offense, so is said to be child in conflict with law.
Okay. Whether a mother, while in the presence of a father, can be a natural guardian.
Uh, so so it is written that father is the natural guardian of the child, but after father, mother is the natural guardian.
If father is there, then
If father is there but not capable enough to be a guardian, so mother can act as a guardian.
only in that case or any other case.
If the father is dead, so then in that, or a
If
deserter,
father is dead, so then father is not there.
not there. Okay, sir.
Okay. What do you understand by this term quick with child? Quick with child.
So the child is to be born in a short period of time. Sir, I'm guessing it.
In IPC, it is written the General Penal Code of India. It does not write Indian Penal Code. Like in Evidence Act, it writes Indian Evidence Act. In CRPC, it writes Criminal Procedure Code. But it writes General Penal Code. Why?
So there must be some legislative intent. I'm not aware of it. So am I audible?
Yes, okay, okay. So you're saying some legislative intent must be there. Okay. Uh, can you tell me what is the function of Niti Ayog?
So it is. It is a central government enactment where it is to provide training to the people for like some crafts person or something like that, sir, as far as my knowledge is concerned.
What is the test of reasonable classification?
Sorry, sir, I'm not aware of it.
Okay. What is your favorite law subject? Please tell me that.
So in general, I love reading law, sir. There is nothing favorite.
Can you tell me the name of certain beneficial legislations?
So beneficial legislations. So
Beneficial social legislations?
social legislation. So prevention of women from domestic violence act.
And
So dowry act.
tell me, in a case, can the prescribed period and period of limitation be same?
No, sir.
Why?
So the period of limitation is the period given in the schedule, but prescribed period is as limitation period as calculated by the sections given in the limitation act, sir.
So it cannot be same ever.
So I'm in doubt.
You're there, you know the concept. Tell me whether it can be the same or not.
Uh, so if there is, sorry, sir.
So the period of limitation, if there is no exception or exclusion, then it
Exactly.
will be same. Then
Yes.
it will
Yes.
be same. So
Yes.
just I'm asking whether there can be a case when there can be no exception or exclusion.
Sir, yes, sir. There can be cases.
Sure.
Not sure, sir.
Okay. Um, legal disability limitation, what does it apply to? What
So,
kind of cases it is applies to?
minor to insane person or to idiotic
So
persons.
what kind of cases I'm saying? Suits, appeal, application, what is it?
So suit and application for so suits and applications.
Application or application for execution of degree?
So I'm in little doubt, sir.
What is your optional subject? Muslim law, Hindu law, or personal law or contract?
The personal law.
What is a dakhul? Dakhul or dakhal?
Sorry, sir, I'm not aware of it.
What is hadia?
Sorry, sir.
Can you tell me what is the doctrine of Rad?
So yes, it is there in Muslim succession doctrine of all and Rad, but so I'm not aware of it.
Okay. What do you understand by caveat venditor?
So I know what caveat is, but the term you said,
Caveat is another thing. Caveat venditor is another concept altogether.
so then I'm not aware of it.
Okay, what is a caveat?
The caveat is presented to a court where then there is a apprehension that there may be a suit filed or application filed against a person to not to pass any order without hearing the caveat.
Okay, okay. Fine, Ankita. Thank you. I'll
Thank you.
come to your feedback after Sir gives the feedback.
Yes, sir.
Okay, let me give the feedback. Sir will join.
Yes, sir.
Yes, you are you are doing well. You know the concepts, but I see that you are not using the legal terms. That means you are explaining in common
Layman
person's
language.
language,
Okay.
layman's language. Okay, so there are, when I ask something, at least the keywords, the takeaway keywords that are there in the legislation, that you cannot miss out. Okay,
Yes. Yes, sir.
like if I instead of good faith I say in good intention, no, that will not work. You're getting
Okay.
it? Good faith is good faith. Good intention, though for a layman it will be same thing. For us it will be different.
Different. Yes, sir. Yes, sir. Agree, sir.
Okay. So that you have to keep it in mind while explaining any answer. You keep in mind that you will use the terms that are used by the legislation, at
Yes,
least
sir.
the key terms. Then around it you build your answer in your own language. That is fine. That is
Yes.
permissible. But at least
Yes.
the keywords that must be there. Okay. And yes, sometimes you tend to give lengthy answers also, like some questions sir asked and you gave very lengthy answers. Sir will comment upon that also. So I think that also makes, I mean, digs a grave for you, because when you give lengthy answer, then there can be possibility of cross question on that. So to avoid cross question, you have to keep the answer very precise. You can't say that this also, that also. If five, 6 lines you are saying, then you are from that line itself, there can be one, two questions. You're
Yes,
getting
sir.
it? So you have to keep it very precise. Okay. Otherwise, the demeanor, how you maintain throughout the interview, the pleasant personality that you have, that is appreciable. Make sure you wear a sari and
Yes.
blazer to the interview with
Yes, sir.
your
Yes.
hair tugged. Okay,
Yes.
you cannot keep it open, and that will be the way to go about it. Now, coming back to the questions, some of the questions that he could not answer.
Yes, sir.
Dakhil or dakhul is consummation. Consummation is called dakhil.
Okay, sir.
Hadia is a gift. Hadia is a gift of a property, that's called it's a gift.
Okay, sir.
Now, why IPC is called the General Penal Code? Because it mentions the general offenses. There are other acts which talks about the special offenses, like NDPS Act is there, like SCST Act is there. But
Yes.
Evidence Act, there is no other Evidence Act. Only one Evidence Act is there. So that's why General Penal Code it says. Caveat venditor, let the normally caveat emptor is let the buyer be aware, but caveat venditor is let the vendor also be aware. Let the
Okay.
vendor also be aware. Caveat venditor and caveat emptor. Caveat emptor is let the buyer be aware. Caveat vendor is let the vendor also be aware. Now,
Okay.
production warrant. Production warrant, when a person is to be produced from jail, is produced through a production warrant. The
Okay.
magistrate will issue a production warrant to the superintendent of jail, directing him to produce the said person who is detained in jail before the magistrate. Okay, that's a production warrant. Now, whether a person in while the father is there, whether mother can be a natural guardian, one thing you said correctly, when he is unable to do so, unable to take care. And second is when there is an illegitimate son or daughter, then in that case also
Father.
the mother will be the natural
Right.
guardian.
Yes, sir.
Okay. Now, reasonable classification. Reasonable classification is, it has to follow two things. That yes, reasonable classification. Article 14, Article 14, 15. If you read together, it says that yes, reasonable classification can be done. You can classify between people, but then that shouldn't be arbitrary, and that classification must be based on an intelligible differentia. That means must be based on a intelligent differentiation. Okay,
Yes.
that is called reasonable classification. Quick with child, that is an IPC. If someone causes someone to abort the child, that's called quick with child. Abort the child earlier than the period. Normally 270, 280 days are there, but earlier than that, if I hit someone's belly, the pregnant woman's belly, and it causes to abort, that is called quick with child.
Yes.
Okay.
Yes, sir.
Now,
So,
yes,
so what was the terms of the consummation? So I need to write. I
dakhil,
couldn't.
dakhil, dakhil,
Sir, another, sir, the gift one.
hadia, hadia,
Dakhal and Hadia. Thank you, sir.
dakhil and hadia. Okay.
Thank you, sir.
Now, what else I was saying? Yes, I was mentioning. What else I asked you? 156.3, whether it is a pre-cognitive stage or a post-cognitive stage. The answer would be, in fact, it is a Previously it was held pre-cognizance, but now it is pre and post both,
Post
by the Binuvai Haribhai case. Binuvai Haribhai case in which it has been held that it can be pre and post both.
the Bin
Okay,
Haribhai case, right?
Binuvai Haribhai. You Google that, it will come up. Okay.
Yes.
Now, protest petition. Protest petition is when you said it right, but then I have a reservation about the use of the words. You should use the words which will be legal words.
So I
Yeah.
have not revised it. So what I understood, I said that.
That is that. That's what it is reflected, that you know it. Your concept is clear. Just that you are unable to reproduce because of lack of revision.
Yes, sir.
So in the last final 5 6 days, what you have to revise everything, because
Yes,
your
sir.
concept is there. If you just look at it once again, the fallible memory that has made sure that we have forgotten it, that will be reminded again. Then we can
Definitely.
reproduce better.
Yes, sir.
Okay.
Yes, sir.
Niti Ayog's function. Niti Ayog is now the planning commission. It's basically has replaced the planning commission, and it basically functions as the planning commission now. It plans all the things that the country intends to achieve or the government intends to achieve. Okay.
Okay, sir.
Uh, that's all. That's all. These are the some of the questions that you could not answer, and I told you. Now, Rad also you could not answer. Rad is also when after assigning the shares, if it is found that the total amount of shares does not exhaust the whole, then in that case it will be given to the
So I
residuaries.
have completely left the succession part of Muslim law, sir. That is why I couldn't.
So you have to again just revise. Okay,
Yes, sir.
make sure that you revise everything, and you'll be good to go.
Yes, sir. Yes, sir.
Okay, thank you. Sir will give the feedback now.
Yes.
Hello, Ankita.
Sir.
My
Sir.
question was, you are becoming very hurry. Take a pause and in a normal manner, as if you are in tension, you are saying everything. But never be in tension like a ordinary way in which you answer. Similarly, you take a pause and don't be hurriedly answer.
Yes, sir.
So that you will get less number of questions.
Okay, sir. Okay,
That
sir.
is
And
another problem. Okay. Après, two or more persons fighting in a public place, that is disturbing public peace. Writing when violence or force is used by unlawful assembly or any member of the unlawful assembly in prosecution of common object of that assembly,
yes.
then only all are guilty for writing.
Yes, sir. Yes,
That
sir.
in Dakaiti, five or more conjointly what is missing.
Okay.
Like the
Hmm.
portion that is very, you have to very careful conjointly. That uh, mischief or whoever intentionally with knowledge causes any damage or destruction to the property of public or of any person. That
Okay,
is
sir.
missing. Fraudulently you are placed in a fraudulently there is some concealment with intention to defraud, concealing certain things. It may not be monetary gain.
Okay.
Fraudulently, any harm can be caused.
Yes.
Dishonestly causing wrongful gain, wrongful loss, you are caught. Murder and culpable homicide. Such a question is put. You take a very long time to answer. So
Yes.
here you have find out the difference is very thin. In
Hmm.
certain circumstances, culpable case becomes murder. There is the intention is more.
Yes, sir.
There is the intention is there to protect. If you go on giving this answer in a murder or culpable homicide, everything, how much time it will take?
Yes,
So
sir.
your answer will be culpable homicide becomes murder in certain circumstances. In certain circumstances, it is simply culpable homicide, not amounting to. That is a thin difference. It will
Yes.
take because various exceptions are there in this. For an if the interviewer examiner wants that give an example, then you miss
Yes.
cheating. Whoever by deceiving any person, it is good. Always remember the keyword deceiving.
Receiving.
Whenever deceiving any fact, any person, intention induces that person to deliver an inducement must be there. And
Yes.
also consent to retain any property. That is cheating. Double jeopardy doctrine, a person cannot be tried for the same offense again if he has been acquitted or convicted. There is acquittal. If there is acquittal there, want of jurisdiction. some from the same fact, a different offences that theft and robbery. I start second class tried case acquitted on the same fact there is robbery that is right. And
Yes.
with consent of the government. It's also sometimes. Police officer arresting warrant without when there is reasonable suspicion that somebody has committed a cognizable offence, he is proclaimed offender. Well, various other things are there. He has also received requisition from other police station by following the provisions laid down from section 41 to 60. These are the
Okay.
parameters. Okay.
Okay.
Criminal misappropriation, whoever appropriates the property of another, that is criminal matter. Criminal breach of trust, there is entrustment. When there
Yes, sir.
is an entrustment to any property and he violates that entrustment in any manner, that is criminal breach of trust. Criminal misappropriation, criminal breach of trust. There is no entrustment.
Yes.
The best example, you found a ring, you did not inquire who is the owner, but converted for your own use. That is contributor negligence when the plaintiff has some amount of negligence. That is in a tort. This
Yes.
contributor negligence term is there. Ryle and versus pleasure is strict liability. This absolute liability also you understood. There in the absolute liability, no exception is
There.
there. That
Yes.
one term you have to keep in mind in Thailand versus pleasure case, he who keeps a dangerous weapon, dangerous premises, dangerous shuttle, let him keep it. That is applicable Thailand versus pleasure. Absolute liability is the thought given by Indian judges. It
Yes,
is
sir.
a different thing. Now, coming to mortgage, specifically, is a transfer of an interest, this term of an interest in specific immovable property as security for payment of
Honey. Yes.
debt. Exchange when two persons mutually transfer the ownership of one thing for another thing. Both the things, neither things money, that is hostile witness, the witness who is produced is not supporting the party who has brought him for examination. It's called a hostile. Document is to be proved. This contents is to be proved by examining the person who has scribed it. That can be, or this handwriting. If the disputed handwriting is there, by handwriting expert, or in handwriting is to be a signature or to prove by examining a person who is acquainted with this signature or handwriting.
Yes.
Character is not relevant in civil case, but in criminal case, when evidence
But
of good character is given, then bad character becomes relevant.
Edel.
Custom and usage. Custom and usage are the same definition in the Hindu marriage act. Any rule which has obtained the force of law, followed from time immemorial, not opposed to public policy, and reasonable. That
Yes,
is
sir.
custom. Requirement for a divorce by mutual consent also you are missing one thing.
Yes, sir.
In the petition it is mentioned they are living separately for 1 year and more. First
But-
requirement.
Yes, sir.
Second requirement, they are unable to live together. Second
Yes.
requirement. Third
Mm-hmm.
requirement, they have mutually agreed to dissolve their marriage by decree of divorce.
Yes, sir. Yes.
Three facts must be there. Then the court satisfied that the petition is not collusive, then not earlier than 6 months, not later than 18 months, and this is. But in certain cases, that can be relaxed.
Yes, sir. Yes, sir.
Women justified to claim maintenance, you are correct also. That is treating the woman with cruelty, fasting, by another keeping a mistress or neglecting, all the things are there. Why on one occasion, you say one or two occasion saying somebody a barren lady will not be a cruelty. One or two occasion, repeatedly say, then this mental cruelty will come. In a
Okay.
normal quarrel, in one occasion, two occasion, if somebody says,
It is
it will
not.
not be treated as cruelty.
Yes, sir. Yes, sir.
Declaratory suit, when somebody's right to any property or status is denied, then he can
Yes.
bring a suit against the person who is denying to declare such right or settle status.
Yes.
Mandatory injunction, enforcement obligation, you are also correct. Then my question was why you are not interested as an advocate. You gave some answer. Yeah. Proper answer may be that it is a prestigious, secured, and independent job. So that
Okay,
is
sir.
why I intend to join as a judicial officer. Very
Okay, sir.
small one.
Okay, sir.
Secure, prestigious, and independent job. You may
Yeah,
not say that is
I go on.
many things. Huh, many things maybe they are in your mind,
Yes,
but
sir.
never disclose it to the interview
Yes.
because one line will solve. Okay, thank you. And we try, don't we answer quickly, answer
Okay.
with a pause in a normal manner.
Yes, sir. Yes, sir.
Okay, thank you.
More way, sir. Thank you, sir. Thank you so much.
Hmm.